Many people have a misconception that one parent has a better right to the children than the other. In Florida, we don't use, for example, the word custody. We use the word parenting plan, and under a parenting plan, there's two different issues that are addressed. One is the parental responsibility and what that looks like between the parents, and the other issue is time sharing. So there is no default as one parent having more rights. Used to be many years ago, there was a tender years doctrine, and moms usually had the majority of the time, but that's no longer. Under our statute in Florida, there's a number of factors that the court looks at when determining time sharing. I would suggest that the most important factor is the best interest factor, which is what is in the best interest of the child. So the time sharing arrangement, number one, as a priority, should take that child or the children's best interest into account. Then they look at the best interest of the parents. What does their work schedule look like? When are they available? Who's the parent that was the primary caregiver? So that, along with a number of other factors, is what the court would consider. A marital and family lawyer should be creative when it comes to the possible arrangements as to time sharing. You know, especially here in Florida, where we have some parents that work in other states, and situations, for example, with airline pilots, where you have to look at their schedules and you have to be creative and come up with options. In some cases, we deal with one parent wanting 100% of the time sharing with the child. And in Florida, generally, the court's best interest, when they look at the best interest factor, they understand that best interest to mean spending time with both parents. Now, the courts in Florida are generally open to that and will award more or less, but not necessarily 100% equal time sharing. They're looking at making sure that the children or the child has a bonded relationship and time spent with both parents. One of the issues in a parenting plan is parental responsibility. Now, there is sole parental responsibility, there's shared parental responsibility, and then there's another concept known as ultimate decision making. Sole parental responsibility is generally for a situation where you have a parent that for whatever reason is not capable of parenting. Maybe they have an addiction issue or they have some other problems going on in their life, so they're unable to actually have time sharing or have the ability to care for their child appropriately. Shared parental responsibility is generally what most parents in Florida end up with. And what that means is that both parents are healthy, have the children's best interest in heart, and they're going to continue to make decisions jointly on major decisions in the child's life, such as what school they're going to attend, if they need to have some medical procedure, who the doctor would be, those types of decisions. Now, in Florida, we also have a concept known as ultimate decision making. And what that means is you start off with the shared parental concept, which is you're going to share the decision making. But if you come to a disagreement as to what that should be, for example, you want the child to go to X private school and your spouse wants the child to go to public school, and so you don't have a meeting of the minds, maybe in ultimate decision, one parent would have the right to make the decisions with regard to education. Time sharing in Florida does have an effect on child support. In Florida, they look at the number of overnights the child has with each of the parent through an entire year. So let's say one parent out of 365 days had 200 overnights and the other parent had 165 overnights. There is actually a formula through the child support guideline worksheets in Florida that would pump those number of overnights into the formula and spit out a child support figure. Now, they also take into consideration the respective monthly incomes of the parties and who's paying the health insurance, but basically there's a child support guideline that works through all that with us. The time that each parent gets to spend with their child is basically based on two things. One, an agreement that you would reach with your spouse or the other parent, and or through the court system, through what's known as a final judgment that would incorporate a parenting plan. Now, the latter, which is through a final judgment, would be when the parents cannot agree as to what that time-sharing schedule would look like. Most parents have the best interest of their children in mind and are able to eventually come to terms on what the parenting plan and the time-sharing looks like. The risk of representing yourself as a parent at what is known as a parenting plan final hearing is that you likely do not understand all of the nuances and the factors pursuant to the statutes here in Florida as to what the court will evaluate to determine who gets what time sharing and what the parenting plan should look like ultimately. You know, parenting plans are one of the most important things that we put together as family lawyers to help the family. And those parenting plans stick with you for years to come. Now, you can ask the court to modify them eventually, but you have to understand that if you make mistakes from the get-go, you're going to be dealing with that until you can get back into the court again to try to rectify any problem there might be. What's different at Yaffa Family Law Group compared to other family law firms is that we really look at different types of representation available to the client specifically. Some firms only, for example, litigate. We also do collaborative law, we do mediation, we do limited representation and consulting. So at Yaffa Family Law Group, we don't have what they call a minimum retainer amount. What we do is we figure out what representation is best for you. We are what they consider a smaller firm, and we usually have team members of about 10, generally anywhere from 5 to 7 attorneys, depending on our caseload. What's unique about that is that we all know, meaning our entire team knows your case. You're not just dealing with one-on-one, one lawyer, one paralegal. You can contact us and most any team member can pick up the phone or get back to you, and they're going to understand the issues unique to your case. During the initial consultation, also known as a strategy session, when you discuss the issues of children, it's a discussion on parenting plans. What you can expect to understand is what is involved in a parenting plan. What are the general factors that the court will look at in determining what's in the child's best interest? And there's a whole list of factors that we would go through during the consultation, and we would then discuss the facts of your case as they relate to the statute. We would then determine the best course of action to get the result that you're looking for.